Hello friends, I welcome you all to lecture number 4 of Indian Partnership Act. This is CA series sponsored by Shrijendra Rangzon and I am your mentor Shekhar Gehlot. Till now, in preceding 3 lectures, we have discussed in detail about partnership, type of partnership, essentials of a partnership, what are partners, how many type of partners are there, okay, and what is the relationship of a partner with the third parties. Now it is time for us to proceed ahead. Okay, now we will begin our discussion with effect of admissions by a partner. Okay, effect of admissions by a partner. Now you people give it a quick read and then we will start discussion. Now, according to section 23, which deals with effect of admissions by a partner. Now, first of all, we must understand what is an admission. This admission is not the admission in a school or a college, which you usually understand with admission, okay? This admission means accepting a fact. Accepting a fact. Okay, this is that kind of admission we are talking about here. That your admission means admitting something, some event, some fact, or some allegation, etc. Now suppose X says that the firm ABC owes 40 lakh rupees to him. Now X is making an accusation, okay, or we can say he is making an allegation, or he is trying to state a fact, or he is trying to tell about some event in which he gave a loan of 40 lakh rupees to ABC firm. Now A is a partner of that firm. He comes out on record. He comes out on record. Record means he makes a statement in writing or through a recording, audio recording or video recording. By record, it means something which can be seen again, which can be checked by other people, which can be verified. He comes out on record and gives it in writing. That yes, the firm owes 40 lakh to X. Now when he comes out and says that the firm owes 40 lakh rupees to X, this is called an admission. Okay, he is admitting a fact that yes, we owe 40 lakh rupees to X, or you may say he is admitting an event that yes, X paid 40 lakh, X gave a loan of 40 lakh rupees to firm, or you can say he is trying to reply to an accusation or allegation in affirmative, in yes, that yes, we have it. Now, what is the effect of such an admission or such an affirmation on the firm made by a partner? Let us read it further. According to section 23, an admission or representation made by a partner concerning the affairs of the firm is evidence against the firm. if it is made in the ordinary course of business. It says an admission or representation made by a partner concerning the affairs of the firm is evidence against the firm. So, when a partner makes an admission, then it will be binding. Okay, section 23 says that the admission made by a partner of a firm shall be binding upon the firm. It shall be binding upon the firm. If, but now there is an exception to this statement, that if it is made in the ordinary course of business, provided such statement should have been made in ordinary course of business. In ordinary course of business. Okay, then only it is a valid statement. Now, what is an ordinary course of business? Suppose a partner of firm goes to make some purchase with shopkeeper B and makes an admission regarding shopkeeper A there. Now, when he is at the shop of a B, okay, in the same market, A also has a shop. Shopkeeper X. X also has a shop. Now, X says ABC has to pay 40 lakh rupees. Now, A goes to the shopkeeper B to make some purchases. And when B asks him, is it true that you people owe 40 lakh rupees to X? He says yes, it is true. This statement is binding. But X B meets A in a wedding party. There, during having food, A makes this admission. Then such an admission shall not be binding, as it is not made during the course of business. Now, what this partner is doing in this party, he is not representing the firm. When we talk about the course of business, we mean that partner must be representing the firm at the point of time. Now, what he is doing in this party, he is just a private person. He is not representing his firm. He has gone there as a capacity, as a personal capacity, and B shopkeeper also came there as a personal capacity, not in the capacity of a shopkeeper. So they both are having an informal discussion. While that informal discussion, A made an admission that yes, we owe 40 lakh rupees to X. Now, this statement cannot be used in the court of law as an evidence because the law says an admission or representation made by a partner concerning the affairs of the firm is evidence against the firm if it is made in the ordinary course of business. Now, what is ordinary course of business? That I have just explained to you with an example, and it will depend upon the case to case basis. What are the ordinary working hours or usage of the particular trade in which the firm is engaged? Partners, as agents of each other, can make binding admissions, but only now partners are agents to each other. We discussed partners are principal as well as agent of each other, can make binding admissions They can make admissions which are binding in nature. Okay, admissions which are binding. But but only in relation to partnership transaction and in the ordinary course of business. An admission or representation by a partner will not, however, now let us read, an admission or representation by a partner will not, however, bind the firm if if when this admission will not bind the firm. Let us read that when this admission will not bind the firm. Now this is the situation. If his authority on the point is limited and the other party knows of the restriction. Okay. If his authority on the point is limited, he has the limited authority and the other party knows the restriction. Now, when can the authority be limited? Let us say A makes a statement to B that ABC firm owes 40 lakh to X. But here A has no knowledge about the accounts. Okay. He makes a statement to, okay, A has no knowledge about the account. Then the accounts, see, when we talk about B here, don't confuse this B with another partner of the firm. Let us say he is some other person. Let's say he is Y. Okay, because name B may be suggesting that he is some partner of the firm only. So now A makes a statement to Y that ABC firm owes 40 lakh rupees to X. But A is not handling the accounts of the firm. Accounts are handled by C and only C has the true knowledge of accounts. Y also knows that A has no knowledge of accounts. Okay, now in this situation, because A is not aware of the accounts of the firm, now 40 lakh is an accounting figure. Whether a firm owes someone a 40 lakh or not, it will depend upon the accounts of the firm. Okay, now A makes a statement, but Y knows and even A knows that A does not have any knowledge about accounting and he does not know whether the firm actually has taken it or not. C, who is the another partner of the firm, handles the accounts and he is the only one who can competently tell whether the firm owes 40 lakhs or not. So in this case, this evidence will not be admissible at all and this evidence shall fail. The section speaks of admissions and representations being evidenced against the firm. Okay, the section speaks of admissions and representations being evidenced against the firm. If some admissions or representations have been made, they will be used as evidence against the firm. That is to say, they will affect the firm when tendered by third parties. It will affect the firm when this Y goes to the court and says that yes, A told me that firm owes 40 lakh rupees to X because Y is the third party. X is the second party, ABC firm is the first party. There is a dispute between first party and the second party. Now Y is the third party. Y goes to the court on behalf of X and says yes, when A came to my shop to make some purchase, he told me that we owe 40 lakh rupees to X. So this is the third party and this admission will work against the firm in a very detrimental way because the partner has made such admission. They may not have the same effect in case of disputes between the partner themselves. However, if there is a dispute between the partner themselves, it may not have such a good effect. But if the firm is having a dispute with a third party, with an outsider, like X is an outsider, then the admissions may be binding. But if this is between the partners, so this will not be binding because partners can, out of jealousy, make several statements against each other. Okay, or partner may, in order to create or fabricate an evidence, may tell some fabricated situation to third party in order to use the statement of third party as an evidence. Okay, let's do the example. X and Y are partners in a firm dealing in spare parts of different brands of motorcycle. Z purchases a spare part from his Yamaha for his Yamaha motorcycle after being told by X. Now X is a partner after being told by X that the spare part is suitable for his motorcycle. Y is ignorant about this transaction. The spare part proves to be unsuitable for the motorcycle and is damaged. X and Y both are responsible to Z for his loss. Okay. And though this example deals more particularly about the agency thing rather than the admissions, but these are the examples which you can understand or read in order to understand what this form is talking about. Okay. Now, effect of notice of acting partner. Effect of notice to acting partner. Okay, you read it and then we will discuss it. Now, let us understand what is a notice. Notice literally means in the basic English language, it means bringing in knowledge. Notice means bringing in knowledge. So, what is the effect of a fact which is brought to the knowledge of an acting partner? Who is an acting partner? First of all, understand. Okay, acting partner, like we discussed. How many types of partners? Acting partner is someone who is active. Okay, active partner. So, what is the effect if some fact is brought to the knowledge of acting partner? Okay, okay. Let us read the section. According to section 24, a partner who habitually acts in the businesses of the firm of any matter relating to affairs of the firm operates as notice to the firm. Okay, a notice to a partner who is habitual in the business of the firm of any matter relating to the affairs of the firm operates as notice to the firm, except in the case of fraud on the firm committed by or with the consent of that partner. We have something called law of notice. There are many laws in which it is a requirement that if you want to file a case against someone, like a case of check bounce, if you want to file a case against someone, then you have to first issue a legal notice. Now, what is legal notice? Legal notice is legally bringing into the knowledge of other party about a dispute. Okay, legal notice means legally. How legally? That means on a piece of paper, okay, in writing. So legal notice means legally on a piece of paper bringing into notice of the other party that there is going to be a case if the dispute is not resolved. So now it says if there is a dispute between the firm and another outsider, and this outsider wants to file a case against the firm, and this outsider wants to file a case against the firm. Now, outsider must issue a legal notice to the firm. Okay, he must issue a legal notice to the firm. Now, this section 24 says if this outsider, suppose X issues notice to A, who is an acting or active partner of ABC firm, then it shall be as good as giving a notice to firm itself. Okay, though in ideal situation, this X should issue a legal notice in the name and address of the firm. Okay, in the name and address of the firm. But if A is a very active partner of ABC, then if X has issued a notice for firm, he has issued a notice against the firm, but he has delivered the notice to A and on his address. And if A is an active partner, then this legal notice shall be a valid notice. And tomorrow, when a case is filed against the firm cannot say that no notice was ever served to the firm by X before filing a case. Then X can very validly say that I had supplied or issued a legal notice to A, who is an acting partner. And firm cannot deny that notice to A is notice to firm, is not equal to notice to firm. Because the section says if a notice is given to the acting partner, then it is equal to giving notice to a firm. The notice to a partner who habitually acts in the business of the firm on matters relating to the affairs of the firm operates as a notice to the firm, except in the case of fraud on the firm committed by or with the consent of the partner. But this position shall not be operative in cases where the acting partner is trying to commit fraud with the firm along with outsider. Okay, if A, the acting partner is found guilty of committing fraud with the firm in connivance or in association with this particular partner, this outsider, then this notice shall not be deemed to a valid notice. Otherwise, in all cases, notice to a acting partner of the firm shall be as good as giving notice to the firm itself. Thus, the notice to one is equivalent to the notice to the rest of the partners of the firm, just as a notice to an agent is notice to his principal. This notice must be actual and not constructive. It must be received by a working partner and not by a sleeping partner, because it says acting partner, not a dormant or sleeping partner. It must further relate to the firm's business, only then it would constitute a notice to the firm. Okay, so these are the formalities which a legal notice has to fulfill in case it is given to a partner of the firm. Okay, these are the formalities which such legal notice should comply, and if after complying with such formalities the notice is given to the partner of the firm, acting partner of the firm, not the sleeping partner of the firm, then the legal notice is going to be a valid legal notice for all legal formalities. Let's do an example here. P, Q, and R are partners in a business for purchase and sale of second-hand goods. R purchases a second-hand car on behalf of the firm from S. In the course of dealing with S, he comes to know that car is a stolen one and is actually belonging to S. X. Now S comes to know PQR. Okay, PQR are partners and R is dealing with the purchase with the S. Now R comes to know that the car is a stolen one belonging to X. It belongs to X, some other person. P and Q are ignorant about it. They do not know. All the partners are liable to X, the real owner. All the partners will be liable to X for committing the crime of purchasing a stolen car. Why? Because there is a notice to R. R has a notice of the fact it is brought to the knowledge of the R that the car is a stolen one and still he goes on to purchase it. P and Q may be ignorant, but they are liable. Why? Because R is the acting partner, and if R has a notice of this fact that the car is stolen car and it actually belongs to X, then it means P, Q, and R all know it. Okay, it is as good as notice to P and Q as well. That means P and Q also know that car is a stolen car. This is the law of notice to the partner. The only exception would lie in case of fraud, whether active or tacit. Now, in case if R is the acting partner, is trying to commit a fraud with the firm in connivance with the S. Who is S? S is one who is trying to sell a stolen car to come to the firm. If they are in connivance with each other, they have a combination, then the P and Q or the firm can set aside its liability by claiming that the partner was committing a fraud with X. So, notice to the partner who is committing fraud is not equal to notice to the firm because he is committing a fraud. Okay, otherwise, the notice is as good as to the firm. A partner who actively participates in the management of the business of the firm bought for his firm certain goods while he knew of a particular defect in the goods. Now he knows that there is certain defect in a good, then also he purchased the goods for the firm. His knowledge as regard to defect ordinarily would be construed as the knowledge of the firm. Now his knowledge of the defect would be understood that the whole firm has a knowledge about the defect, though the other partners in fact were not aware of the defect. But because A had in league with the seller, A was in league with the seller, that means A purposely purchased a defective good, okay, conspired to conceal the defect from the other partners. The rule would be inoperative and the other partners would be entitled to reject the goods upon detection of them by the defect. Okay, now other partners will be entitled to reject the goods. Why? Because A is in league or in connivance with the seller. Liability to third parties, section 25 to 27. You read it for a minute and then we will come back with the discussion. Liability to third parties. The question of liability of partners to third parties may be considered under different heads. These are as follows. These are the headings under which the liability to third party can be understood. Every partner is liable. Now, every partner is liable. It begins with liability. Jointly with all the other partners and also severally for all acts of the firm done while he is a partner. Jointly and severally means separately or independently. Okay, that means a case can be filed against the firm, whole firm and all partners, or against one individual partner alone and not against the other partners. It is the choice of the one who is filing the case against whom he wants to file a case. If there are five partners in the firm, he can file a case against five of them, all of them, or he can file against only two and may not file against the other three. This is his choice against whom he wants to file a case. Okay, and that is allowed by the law. So, a partner is liable jointly when a case is filed against all of them, or severally when a case is filed against him only. Okay, for the acts done in the firm while he is a partner. While he is a partner, now when we talk about partner, partner is any partner. We are not talking about acting partner here. Sleeping partner, dormant partner, holding out, and every partner who's a partner meanwhile in the firm is liable for the acts of firm. It is immaterial whether the act of the firm was committed with the knowledge of this partner or with the consent of this partner or not. He may not be aware. He may be completely unaware that firm is going to take such decision. Okay, but just because he is a partner, it is understood, it is deemed, it is presumed that every partner of the firm knows of the decisions of the firm. He may not be knowing it, but we will believe that he knows it, and if a case is filed against the firm, he is also liable because he was a partner and he was deriving benefits out of the actions of the firm because he is a partner in the profits. Okay. Analysis of section 25. The partners are jointly and severally responsible to third parties for all acts which come under the scope of their express or implied authority. Okay, for all acts which come under the scope of their express or implied authority. And implied authority of a partner is very wide. Okay, express authority may be limited. He may be only an accounting partner, but implied authority is very wide. An accounting partner also has an implied authority to make purchase, to act as a purchasing partner. Okay, if the third party is not aware. So implied authority is very wide. This is because that all the acts done within the scope of authority are the acts done towards the business of the firm. Okay, whatever act is done by a partner for the firm is done for the benefit of the firm. So when something is done for the firm, all partners of the firm are liable because ultimately, if there would have been a profit, all partners would have enjoyed that profit. So when there is a loss or a liability, all partners should equally suffer that liability as well. The expression act of firm connotes any act or omission by all the partners. Act means positively doing something. Omission means failure to do something. Okay, omission means failure to do something. Okay, act is doing something, omission is
It's
not doing
11
something or
o'clock.
failure to do something. Connotes any act or omission by all the partners or by any partner or agent of the firm, which gives rise to a right enforceable by or against the firm. Okay, so it is an act or an omission which gives rise to an action against the firm. So when there is an action against the firm, because firm is not an independent entity, it has no corporate will. So definitely the case is going to be filed against the partners. Again, in order to bring a case under Section 25, it is necessary that the act of the firm, in respect of which liability is brought to be enforced against a party, must have been done while he was a partner. Okay. So when someone has ceased to be a partner, has ceased to be a partner and has given proper notice to public of his retirement, then he would not be liable for acts of the firm committed after his retirement. Only for act of the firm committed after his retirement. So if he was a partner and firm committed a mistake, okay, but meanwhile he retired and the case is filed against the firm after 3 years, after a gap of 3 years. But the act was done when he was a partner. But the case is being filed when he has already retired and given a proper public notice. Then also this partner who has now retired will be liable. Okay, will be liable. The crucial date for liability is the date of the act or omission. The crucial date is not the retirement or the dismissal of a partner. The crucial date is date of act. If on the date of that act or omission for which the firm is responsible, he was a partner or not. If he was a partner on that date and later on he retired, then also he will be liable. It is not that you commit an offense and then take a retirement and say that I am not liable. This cannot be done. Example: certain persons were found to have been partners in a firm when the acts constituting an infringement of a trademark by a firm took place. Infringement means illegal use of some other trademark. Infringement means illegally using others' trademark. Okay, illegally using someone else's trademark, like I have a firm, but I am producing my products with the trademark of Tata. I cannot do that. Okay, so that is called an infringement of trademark. Okay, infringement of the trademark of Tata. Okay, certain persons were found to have been partners in a firm when the acts constituting an infringement of trademark by the firm took place. It was held that they were liable for damages arising out of the alleged infringement. They all were liable for the damages suffered by Tata for the illegal use of their trademark. Okay, because Tata produces good product and the firm produced substandard product and sold them by the name of Tata. So Tata's reputation definitely goes down when the products which are substandard, not produced by Tata, are sold as the in the name of Tata. So Tata will say that there is an infringement of my trademark and my reputation has suffered a damage. Now this firm is liable. So whoever was the partner on that date will be liable for these damages. Okay. It is immaterial that the damages arose after the dissolution of the firm. Okay, damages may have happened after the dissolution of the firm. We were discussing a situation in which a partner has retired. Here, there is a situation in which the whole firm has dissolved. The whole firm has gone out of the existence. But what is the crucial date? Again, the crucial date is the date of act of omission. On that act or omission, on date of infringement of the trademark, the firm was in existence. Later on, when the Tata came to know that there is an infringement of the trademark, firm had already closed down its business, but the partners will still continue to remain liable because they have committed a fraud with Tata. So this is the liability of the partner. Okay, what is the liability of the partner? Liability of the partner is joint as well as independent. Okay, now what is the liability of partner? Joint as well as independent. He has a joint liability, all partners together or independently. Okay, he is liable in both ways. A case can be filed against the firm as a whole, including all the partners, or a case can be filed only against one partner or two partner and not against the rest of the partners. It is the choice of case filing person against whom he wishes to proceed. Second one is now we are discussing it liability to third parties. Okay, this is within the heading of liability to third parties. First liability is liability of the partner for the acts of the firm. Now what is the second type of liability to third parties? Third parties means which are outsiders. Where by the wrongful act or omission of a partner in the ordinary course of the business of the firm. Now we all know what is the ordinary course of business of the firm, so we do not have to spend much time in discussing the ordinary course of business of the firm. Okay, so where by the wrongful act or omission of a partner in the ordinary course of the business of the firm or with the authority of his partners, okay, loss or injury is caused to any third party or any penalty is incurred. Some third party has suffered a loss because of the act of this particular person, a partner, or any penalty is incurred. A legal penalty, some fine has been imposed on the third party because of the act of this partner or the firm. The firm is liable, therefore, to the same extent as a partner. Okay, so now this is the fault of a partner. Okay, the fault of the partner, but the whole firm is liable. In portion 1, in part 1, we read the partner is liable for the act of the firm. Here we are reading the firm is liable for the act of the partner. That means both firm and partner are liable towards the acts of each other. If a partner commits a wrong, the firm is liable. If the firm commits a wrong, the partner is liable. Okay. So now where a partner has committed something due to which someone has suffered a penalty, then the whole firm is liable. Analysis of section 26. The firm is liable to the same extent as the partner for any loss or injury caused to a third party by the wrongful acts of a partner, if they are done by the partner while acting. Okay, but the firm shall be liable only in these cases if the actions which have caused this injury are done while in the course of business, in the ordinary course of the business, okay, or with the authority of the other partners, with the authority of the other partners. So when a partner does not have the authority to do something and he still does it, only he is liable. Okay, only he is liable, provided that the other party was aware about the authority of the partner. Okay, so if a partner does something outside his authority, only he will be liable if the third party was aware of such restriction in the authority of the partner. If the third party was aware that this partner does not have the permission to do so and he is doing it, then only he individually will be liable. But if the other party is not aware, okay, that while he is acting in the ordinary course of business but he does not have the authority to do so, if the third party is not aware about such restriction, then the whole firm shall be liable because of the principle of the implied authority of the partner. Okay, and we have in detail discussed the implied authorities of the partner. If the act in question can be regarded as authorized and as falling within either the categories mentioned in section 26, these are the categories. The fact that the method employed by the partner in doing it was unauthorized or wrongful would not affect the question. Furthermore, all the partners in a firm are liable to third parties for loss or injuries caused to him by the negligent act of the partner acting in the ordinary course of business. So the whole firm would be liable. One of the two partners in a coal mine acted as a manager was guilty of personal negligence in omitting to have shaft of the mine properly fenced. Okay, as a result thereof, an injury was caused to a workman. The other partner was also held responsible for the same. So, one partner did not maintain the shaft in a coal mine and the shaft fell on someone, and the other workman suffered the injury due to the negligence of this partner. Now, the other partner shall also be held responsible to pay compensation to this workman, though this other partner has no role to play here, but because they are acting as a firm, so they both should suffer the liability together. Okay. Now, the third liability to other party is liability of a firm for misapplication by partners. Liability of firm for misapplication to the partners. You give it a reading and we will come back for discussion. A partner acting within his apparent authority means implied authority. A partner acting within his apparent authority receives money or property from third party and misapplies it. Now we are talking about misapplication. Okay, misapplication means wrong application. Okay, mis means wrong, application means using. So wrong application or wrong use. Okay, wrong use of something, wrong use of funds, wrong use of goods. Okay, goods were meant for sample and sample, but partner sold sold that. Okay, this is kind of misapplication we are talking here. A partner acting within his apparent authority receives money or property from a third party and misapplies it. Or a firm in the course of its business receives money or property from a third party and the money or property is misapplied by any of the partners while it is in the custody of the firm. The firm is liable to make good for the loss. The firm is liable to make good for the loss. Suppose firm is giving loan on gold. Okay, just like Muthoot Finance, people take their gold chains or gold ornaments, keep it with the firm. Firm gives them the loan, and when they repay the loan, the firm will return the gold item. Okay, firm will return the gold ornament after loan has been repaid. But a partner has sold that ornament and used the money. The third party has repaid the loan, but gold is already sold. This is a case of misapplication of property or money with firm. Okay, this is a case of misapplication of the property or money with the firm. Or A owed 2 lakh to firm. He gave 2 lakh to the partner as repayment of the loan, but the partner used the money as his own. Partner used the money as his own. Okay, and now firm is also asking money back. In these cases, these are the cases of misapplication by partners or misapplication by the firm. Portion A discusses misapplication by the partner and the firm shall be liable. Or portion B is also when portion A is when something is received by a partner on behalf of the firm and he misapplies it. Or something B is when something is received by the firm and it is in the custody or possession of the firm, but meanwhile the other partner abuses it. Analysis of section 27. It may be observed that the workings of the two clauses of section 27 is designed to bring out clearly an important point of distinction between the two categories of cases of misapplication of money by partners. That means there is a distinction between both the categories. Okay, clause A covers the case where a partner acts within his authority and due to his authority as a partner, he receives money or property belonging to a third party and misapplies that money or property. For this provision to be attracted, it is not necessarily necessary that the money should have actually come into the custody of the firm. Okay, so it is not mandatory that money should have actually come to the firm, but if it came to the partner, then it is ultimately and presumed to have come to the firm only. Okay. On the other hand, the provision of clause B would be attracted when such money or property has come into the custody of the firm and it is misapplied by any of the partners. The firm would be liable in both the cases. If receipt of money by one partner is not within the scope of his apparent authority, his receipt cannot be regarded as a receipt by the firm, and the other partners will not be liable unless the money received comes into their possession or under their control. Okay, it says that if the receipt of the money of the by the partner is not within the scope of the apparent authority, apparent or the implied authority. Okay, if he did not have the authority and the other party knows that he does not have the authority to receive money on behalf of the firm, then the firm is not liable, then the firm will not be liable. Okay. Rights of transferee of a partner's interest. Transferee, rights of the transferee of a partner's interest. What is a transferee? Transferee is a person who has purchased the share of outgoing partner. Transferee means something is transferred to that person. Like if I transfer something to A, then I am transferor and A is transferee. Okay, I transfer a watch to B. I am called transferor. B shall be transferee. Okay, B shall be transferee. So what we are going to discuss here, we are going to discuss rights of transferee of a partner's interest. Transferee of a partner's interest. If the partner has sold out his interest in the firm, that means the transferee or a new partner will come up. So the transferee who has purchased the share of this partner, what are the rights of such a person who has purchased the rights of the partner? A. A transfer by a partner of his interest in the firm, either absolute or by mortgage or by creation of him of a charge on such interest. Now, absolute means he has sold it off absolutely. Okay, like I sell my watch to someone, I have absolutely sold the watch. Now, the other person can give the watch to someone, or he can wear it himself. He can sell it in the market, or he can destroy it, or he can just let it in his drawer like this only. That is called absolute transfer when no right is left with the seller. By mortgage, mortgage means you are keeping it as a security. Okay, mortgage is keeping it as a security. Like gold loan, you keep your gold as a security, and when you repay the loan, you take back your gold. Gold does not belong to Muthoot. Muthoot will get the gold only if you fail to repay the loan. If you are repaying the loan, gold will remain yours. Muthoot cannot misapply your loan, and if Muthoot does so, Muthoot will be liable to give it back to you or damages. Similarly, interest of a partner is mortgaged. Mortgage of interest, mortgage of partner's interest. That means he has taken some loan from someone and mortgaged his interest in the partnership with the one who has given him the loan. Now, that does not mean the other person has become the partner. It means only that he is a partner in profits. He'll take the share, he'll take the profit of this partner till the time loan is not repaid and this mortgage is not closed or shut down or redeemed. Okay, or by creation by him of a charge on such interest. Charge is again like keeping something as a security. A transfer by partner of his interest in the firm, either absolute or by mortgage or by creation by him of a charge on such interest, does not entitle the transferee during the continuance of the firm to interfere in the conduct of business or to require accounts or to inspect the books of the firm, but entitles the transferee only to receive the share of profits of the transferring partner, and the transferee shall accept the accounts of profits agreed to by the partners. Okay, that means If one partner has sold off his share to an outsider X, he has sold off his share to an outsider X, or he has created a mortgage in favor of X, or he has created a charge in favor of X. Whatever be the case, okay? Either he has absolutely sold it or by way of mortgage or by any other name. This person X shall have no right at all in the business of the firm. Neither he shall have power to see books of accounts. Neither he shall have any voting right at all. Only right he would get will be to take profits from the firm. Okay, profits for the firm which the partner who has sold his share was entitled to receive. Okay, a partner usually has all the rights. Okay, he has a right to vote, he has a right to inspect the book of accounts, he has right to take part in the business of the firm. But here, in this case, he will not be allowed to do. He has purchased the share, but still he has purchased only the profit. Only right to receive profits, this section says, only right to receive profits can be sold and not the partnership. Okay, not the partnership of this person. I have a partnership with other people. I cannot sell my partnership. What I can sell is I can only sell my right to receive profits. Okay, that means I cannot sell myself and bring some other partner. Because the crux of partnership lies in mutual faith, trust, confidence, etc. Because the partnership arises out of the mutual trust, confidence, faith, okay, between some people like A, B, C, D. Now these four people have a mutual trust. Now D tomorrow sells his share to Z. Now A, B, C, okay, A, B, C, D are partners. D sells share to Z. D sold his share in partnership to Z. Now, can this Z have same level of understanding? Can this Z now have same level of understanding, trust, faith and confidence with the other partners? He may or he may not. If he may, then definitely all the partners will admit him like a true partner. But if they feel that we do not have same level of trust with the Z, but D is willing to sell his share, we cannot stop the D. But then D will sell his share and Z, this person who has purchased the share, will get only right to profit. He will not get right to interfere at all. Okay. And the transferee shall accept the account of profits agreed to by the partners. Okay. And transferee and this Z shall get only that profit which other partners have agreed to give to him. That's it. Okay. If the firm is dissolved or if the transferring partner ceases to be a partner, the transferee is entitled as against the remaining partners to receive the share of the assets of the firm to which the transferring partner is entitled and for the purpose to ascertain that share to an account as from the date of dissolution. Okay. If the firm is dissolved, Okay, now you do not allow him to inspect the accounts of the firm while the firm is in business. But now the firm is dissolved. Now when the firm is dissolved, that means no business is left with the firm. Now he can seek the accounts. Now on the dissolution of the firm, he can seek the accounts of the firm. Why? In order to check that whether the distribution of assets is fair or not. Okay, how would he come to know that what assets he has received out of the dissolution of the firm? Is that distribution fair or not? He will get to know only upon the inspection of the accounts. We do not give him right to interfere in the business, and because business is going on, he cannot see the business accounts. But when the business is closed, shut down, firm is dissolved, then definitely his right is there to see the books of account. You cannot prevent someone in perpetuity to not to see the book of accounts. Okay. Analysis of section 29. A share in a partnership is transferable like any other property. But as the partnership relationship is based on mutual confidence, the assignee of a partner's interest by sale, assignee means transferee, okay? Sale, mortgage, or otherwise cannot enjoy the same rights and privileges as the original partner. The right of such a transferee are as follows. These are the rights. During the continuance of partnership, such transferee is not entitled to interfere with the conduct of business, to require accounts, to inspect the books of the firm. Okay. He is only entitled to receive the share of the profits of the transferring partner, and he is bound to accept the profits as agreed to by the partners. That is, he cannot challenge the accounts. Okay, till the time the firm is in operation, till the time firm is working, functioning, whatever profit is given to him, he has to take that. He cannot challenge it. Okay, unless it is highly unjust. Okay. Now, what are his rights on the dissolution of the firm? On the dissolution of the firm or on the retirement of the transferring partner, the transferee will be entitled against the remaining partners. Now, the transferee will be entitled against whom? Against the remaining partners. And what is his entitlement against the other partners? Let us see. To receive the share of assets of the firm to which the transferring partner was entitled. He will get the share which the partner who has sold his share was entitled. Okay, whatever share the selling partner was entitled to, he will now receive that same share, not more, not less. For the purpose of ascertaining the share, he is entitled to an account as from the date of dissolution. After the date of dissolution of the firm, only after the dissolution of the firm's assets can be sold and can be divided. So after the dissolution of the firm, he will get the right to inspect the accounts of the firm. Okay. By virtue of section 31, which we will discuss hereinafter, no person can be introduced as a partner in the firm without the consent of all the partners. Okay, no person can become partner without the consent of all the partners. Consent of all the partners, not majority. Very important to understand, very important to note down. Okay, it is not a majority rule, it's a unanimity rule. Only unanimous consent of all the partners. 100% yes for a new partner, then only a new partner could be added. Otherwise, not. Even if one person says, no, 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 I do not accept him as a partner, then the person cannot be added as a partner to the firm. Why? Because we know the reason. Because partnership is based upon mutual confidence, faith, trust, and fairness between each other. A partner cannot, by transferring his own interest, make anybody else a partner in his place, unless the other partners agree to accept that person as a partner. At the same time, a partner is not debarred from transferring his interest. A partner's interest in the partnership can be regarded as an existing interest and tangible property which can be assigned. A partner's interest in the partnership is regarded as a property which he can sell. Okay, if I have a property, I can sell it. Similarly, a partner's interest in the partnership firm is understood as a property which he has a power to sell. But when he sells it, it is not that the buying person, the person who has bought the share, will automatically become a new partner. He will be inducted as a new partner in the firm. No, but yes, he can be inducted as a partner in the firm only and exclusively when there is a unanimous consent by all the other co partners of the firm. Even if one of the partners resiles and says, no, I do not allow this person to be the partner in the firm, the person who has bought the share will be merely a partner in profits only and not a full fledged partner, and he will not have all the rights of a complete partner. Minors admitted to the benefit of a partnership. Section 30. Now, we all know a minor definitely is not competent. He is not having capacity to enter into a contract or an agreement. And we know partnership comes out of an agreement between the partners. So when a minor cannot enter into an agreement, that means minor cannot enter into a partnership. Okay, but can he become partner of benefits? Okay, let us read it. You give it a reading, and we'll begin the discussion within a minute or two. A person who is a minor according to the law to which he is subject may not be a partner in a firm. But that means something can happen. He may not be a partner, but still something can happen. And what is that something? Let us read. With the consent of all partners. Now, the consent of all partners. The consent of all partners required to do this something. And what is this something? For the time being, he may be admitted to the benefits of partnership. He may be admitted to the benefits of the partnership. Such manner. Now, what is this admission to benefits? Now, what is admission to benefits of a minor by the firm? Okay, let us read. Such minor has right to such share of the property and of the profits of the firm as may be agreed upon, and he may have access to and inspect and copy any accounts of the firm. He is virtually having all the rights of a partner. Okay, he is virtually having all the rights of the partner. A minor is virtually having all the rights of a partner. Why I say virtually? Why virtually and not really? Virtually means it appears that he has all the rights. He has a right to share in the property, he has a right in the profits, and he can have the access and he can inspect and he can have the copy of the accounts as well, which we are not allowing even to a person who has legally purchased a share. But a minor can do so. Oh, so okay. So minor is virtually having all the rights of the partner. But when I say virtually, that means it is only apparent. Virtually means it appears, but it is not really. Okay, a minor is virtually having all the rights of the partner. Why virtually and why not really? Because he cannot act in business. Because he is a minor, he cannot be an acting partner. Okay, a minor cannot be an acting partner. So he has all the rights of a partner, less, okay, minus the rights of working. So these are the rights which a minor has if a minor is admitted to the partnership. But how can a minor be admitted to the partnership? It can be with the consent of all the partners for the time being. Okay, suppose only for a month, only for a year, the partners can decide. And if partners decide that he should leave, then he should leave. Okay. Such minor has right to such share of the property and of the profits of the firm as may be agreed. He will have such share in the property and such profit as agreed by the partners. Whatever share partners feel that this minor should get 2% share, he'll get 2%. If the partners agree that he will get one house of the firm and he will get 10% of the property, then he will get it so. Okay, so it all depends upon the partners alone. Such minor's share is liable for the acts of the firm, but the minor is not personally liable for any such act. Such minor share is liable for the act of the firm, but minor is not personally liable. Okay, a minor has been admitted into the firm as a benefits partner. He is given a house and 4 lakhs rupees per year as a lump sum profit, okay, which the firm makes. Now, what is the position here? Position is that if tomorrow firm contracts some liability, okay, the firm has to suffer some liability, then we cannot say that what this minor has got the flat or the house of 4 lakhs, we cannot legally take it back from him. Okay, if the firm has a liability and firm is not able to discharge it, the creditors of the firm, creditors means who have to take money from the firm, creditors of the firm could take this house as well as the money which is still with minor. If minor has consumed the money, then he has consumed the money. Otherwise, if he still has the money, we can take it from him. But minor cannot be personally liable. That means we cannot attach. That means other assets of the minor could not be sold. Other assets than the assets which he has received from the firm could not be sold. They are his personal assets. Plus, he could not be sent behind the bars. Yes, a major partner, an adult partner, can definitely be sent behind the bars for the actions of the firm, but a minor is insulated from such. A minor cannot be sent to the bars. Why? Because the law provides him that immunity, that blanket cover. Such minor may not sue the partners for an account or payment of his share of the property or profits of the firm, save when severing his connection with the firm. Now, this person, this minor, he has been admitted to the benefits of the partnership. And after admission, he is not being paid. They are not paying him anything. Okay, they are not giving him share. They are not showing him the books of account. He is entitled, but they are not showing him. He cannot file a case against them. Okay, only case when he can file a case against them for showing books of accounts or for receiving of the profits is when he is severing, when he is terminating his connection with the firm. If he is in the firm, he cannot do so. He'll have to rely upon the firm. Whatever firm gives, he'll have to take because he is a partner in profits only. Okay, he is not doing any business for the firm. So firm may sometimes not give him anything. So he cannot file a case for such. But when he is terminating his connection with the firm, then he can definitely claim that amount. Okay, claim that amount and can claim that he be shown the books of accounts as far as possible, and valuation will be made of his share, and then court will decide how much amount he has to be paid. Provided that all the partners acting together or any partner entitled to dissolve the firm upon the notice to other partners may elect in such suit to dissolve the firm, and thereupon the court shall proceed with the suit as one for dissolution and for settling accounts between the partners, and the amount of share to the minor shall be determined along with the shares of the partners. Okay, it depends if he has filed such case that I do not wish to be the member of the partner of the firm anymore. He has filed a case, then the firm can dissolve itself as well. The firm can dissolve itself as well, and then court will determine the value of share of the partners as well as the minors' share. Okay. At any time within 6 months of his attaining majority. Now, what will happen when this minor attains majority? Definitely someday this minor will become an adult, isn't it? A minor will definitely become an adult on attaining the age of 18, and if he is alive, definitely he will attain the age of 18. It's a certain thing, it is bound to happen by the law of nature. Okay, what will happen to this minor after attaining majority? What will happen to this minor after attaining majority? Let us see. At any time within 6 months of his attaining majority. Now, at any time within 6 months, that means he has a fixed period by the law, that is 6 months. At any time within 6 months from his attaining majority, that means within 6 months, minor has to take an action. What is that action? Let us see. What is that action which he has to take within 6 months of attaining majority or of his obtaining knowledge that he had been admitted to the benefit of partnership, whichever date is later. Now, suppose he has attained the majority but he is not aware. He does not know that I am a partner of such firm. When he was made a partner of benefits, he was really very small kid and he does not know it till now. So he attained majority, but he came to know of such partnership only after 21 years, when he has become 21 years of age. That is 3 years after turning adult. So law says the 6 months time limit will begin either on turning 18 or either when he comes to know, suppose 21, 28, or whatever date is later. Okay, if this date is later, then from this date we will count 6 months. If he knows it already and after attaining and he has become adult, then we will count it from the date he turned 18. So 6 months, within 6 months, he has to take an action. What action he has to take? Whichever date is later. Such person may give public notice that he has elected to become or that he has elected not to become a partner in the firm, and such notice shall determine his position as regard to the firm. Within 6 months, he will issue a public notice. What this public notice will be, that he will remain a partner or not. He will give a public notice that whether he choose to remain the partner of the firm on attaining majority, or he may choose not to be a partner at all. That I was a partner when I was minor. My father made me a partner in the profits. Now I have become adult. I can take my own decisions. I choose not to be a partner of this firm. Okay, whatever be the case. Okay, but within 6 months, he has to take an action. What is that action? He has to issue a public notice. And in that public notice, what he will display? He will tell people whether he has elected to remain a partner or not. Okay. Provided that, provided that if he fails to give such notice, now within 6 months of getting knowledge or attaining majority, if he fails to give such notice, he shall become a partner in the firm on expiry of such 6 months. Within these 6 months, the court or the law gives him a choice that if you want, you issue a public notice, and you want to leave it, you leave the firm. But if within these 6 months, minor who has just turned major adult, he does not take any action. Okay, if he does not take any action, then he will have to leave the firm. Sorry, he will automatically become a partner of the firm. Automatically become a partner of the firm, whether he wants to be a partner of the firm or not. And what is the I mean what is the legal incident Legal incident means what is the legal consequence of becoming a partner and a partner who's an adult. That means from now onwards, you shall be liable for the acts of the firm. As a minor, he was a partner in benefits only. He was having no liability at all. Okay. Such minor share is liable for the acts of the firm, but the minor is not personally liable for such act. But now, after attaining the majority, this person who has become an adult and he has not given a public notice. And law says within 6 months, if you do not give such public notice, you shall become a partner in the firm. So that means from this date onwards, whatever the firm does, he will continue to become liable for the actions of the firm. Personally liable, not liable towards his share alone, but personally liable he would be. Okay, this is the legal consequence of him not choosing to give a public notice. Where any person has where any person has been admitted as a minor to the benefits of partnership in a firm, the burden of proving the fact that such person had no knowledge of such admission until a particular date after the expiry of 6 months of his attaining majority shall lie on the person ascertaining that fact. Minor was a partner. Minor became adult. Minor did not give any notice. Automatically became an adult and liable partner. Firm has now contracted some liability, and this person means this new partner is facing a court case. This person is facing a court case. Now this person takes a defense. He says that I did not know that I was a member, I was a partner of such partnership. If I knew it, I would have given a notice and left the firm. Because I did not know it, my 6 months period has not started. Today I have come to know because of this case that I am a partner in such firm and I give a notice that I do not choose to become a partner. So I am not liable because I was not aware. Now who shall have to prove it? Court says after expiry of these 6 months, thus minor will have to prove if he has not given a notice within 6 months and later there is a liability and he says he was not aware, then it shall be the responsibility of the minor who has become adult to prove that he was not aware of such share in partnership. Okay, it shall be his responsibility. But law will otherwise presume. Okay, it shall be his responsibility, but law will otherwise presume that he knew it. On the attaining majority, on the date he turned 18, he had a knowledge. It's 12 o'clock. That he was a member of he was a partner in the partnership. He knew it, and now he has become a liable partner. Court will assume it. Court will believe it. Now it will be the duty of the minor to prove this belief wrong. Okay. Where such person becomes a partner. Now this person has failed to give a notice or has given a notice and says I choose to become a partner. What will happen when this person has finally chosen to become a partner of this partnership firm in which he was admitted as a minor but only in the profits. What will happen to him? What is his case in the law? Read it and we will get back within a minute or two. Now, what will happen to such person who has now become a partner and he is an adult partner? A. His right and liabilities as a minor continue up to the date on which he becomes a partner. On which date he becomes a partner? Suppose he gives a public notice on the last date of this 6 months. So he will become a partner on 18 and half years of age. Okay, so on 18 and half years of age, till that time, his right and liabilities as a minor will continue up to the date on which he becomes a partner. Till the date he becomes a partner, his rights and liabilities will that be of a minor only. Okay, that means he has no liability at all. Liability towards his share only, but not personal liability. Okay, but he also becomes personally liable to third parties for all the acts of the firm done since he was admitted to the benefit of partnership. Now, this is a very key point. This is a very key point. He will become personally liable. He will become personally liable. What is this? Sorry. Personally liable to third parties for all the acts of the firm done since he was admitted to the benefits of the partnership. Suppose he was admitted to the benefit of the partnership when he was 13 years of age and now upon 18 he becomes a partner. That means now he shall be liable personally for all the acts done by the firm within those 15 years. Okay, for those previous 15 years as well, he will be liable. So he must make a good choice. He must check the background of the company before electing to become a partner in such a case because for previous 10 to 15 years, whatever company has done, the firm has done, sorry, and the minor, because he does not have much greater right to inspect the accounts, may not even be aware of the liabilities the firm has contracted. So it will be a very tricky position. If he chooses to remain a partner, he will become liable even for the previous acts which are done when he was a minor and had no control at all in the decision making of the firm. When he was a minor, he had no control in the decision making of the firm, but he will become liable for whatever decisions have been taken by the firm since his date of admission as a partner in benefits. So that is a very tricky position for him. His share in the property and profits of the firm shall be the share to which he was entitled as a minor. That means his share will not change, his share will still remain as it is, as it was when he was admitted to the benefits as a minor. Where such person elects not to become a partner. Okay, where such person elects not to become a partner, what will happen? Now we have discussed what will happen when he chooses to become a partner. Now let us see what shall happen when he chooses not to become a partner. Upon 18, he gives a public notice and he says that I terminate my partnership with that particular firm in which I was admitted into benefits as a minor. What will happen? His rights and liabilities shall continue to be those of minor under this section up to the date on which he gives this public notice. That though he has given the public notice on 18 years and 6 months, because he is given 6 months time, so he has given the public notice on the last date of the expiry of 6 months. Okay, so 18 years and 6 months, but he will be treated as a minor only. Though he has become an adult for all the purposes of law and he is 6 months more into adulthood, but because he has within those 6 months at the expiry at the last end of that 6 months time limit, he has given a public notice that I do not wish to stay as a partner of this firm. He shall be treated as a minor till the date he has given a public notice. Now, what does it mean that he shall continue to be a minor? That means he shall not be treated as an adult, and his personal liability will not be in question at all. He will not become a personal liable. His share shall not be liable for any acts of the firm done after the date of his notice. Now he has a share in the firm. Okay. And the firm has not given him his share till now. He has not become a partner. He has severed his he has severed his contact with the firm, but still firm has to pay his share. Suppose firm has to pay him 50 lakh rupees. Okay, and firm contracts some liability. Then those 50 lakh rupees shall remain untouched. Okay, that 50 lakh will not be liable because he is not a partner and firm has to give him. Okay, so that 50 lakh will not be liable for the acts of the firm done after that date of notice. For whatever liability the firm will contract after he has given such public notice, his share will not be liable because otherwise his share was liable as a minor as well, but only he was not personally liable. But because now he has chosen to remain a minor and to serve his contract with the firm, then his share shall no longer be liable. He shall be entitled to sue the partners for his share of the property and profits in accordance with the subsection 4. He shall be able to file a case against the firm as well as the partners that these people are not giving me my share, or they are not showing me accounts, or they are not giving me my profits. Okay, so he shall have legal right to file the case against partnership in such cases. Nothing in subsection 7 and 8 shall affect the provisions of the section 28. Okay. So nothing in section 7 and 8. Anyhow, this is not still for the academic purpose. Let us read. Nothing in section 7 and 8 shall affect the section 28. What is 28? 28 is the, okay, 28 is, okay, there is no section 28. Probably something not relevant for your part of syllabus. Let's delete it from here. Analysis of section 30. You have observed that a minor cannot be bound by a contract because a minor's contract is void and not merely voidable. A minor's contract is void and not merely voidable. We have understood the difference between void and voidable. Void can never be made valid, but voidable can be made valid by the option of one party who has option to treat this contract as void. Okay, so that is the basic difference between void and voidable. But a minor's contract is void. That means no one can treat it as a valid one. Okay, it remains void. Therefore, a minor cannot become a partner in the firm because partnership is founded on a contract. Though a minor cannot be a partner in the firm, he can nonetheless be admitted to the benefits of partnership under Section 30 of the Act. In other words, he can be validly given a share in the partnership profits. When this has been done, and it can be done with the consent of all the partners, then the rights and liabilities of such a partner will be governed under Section 30 as follows. These are the rights and liabilities of such a partner. A minor partner has a right to his agreed share of profits and of the firm. He can have access to, inspect, and copy the accounts of the firm. He can sue the partner for the accounts or for the payments of his share, but only when severing his connection with the firm and not otherwise. On attaining majority, he may, within 6 months, elect to become a partner or not to become a partner. If he elects to become a partner, then he is entitled to share to which he was entitled as a minor. If he does not, then his share is not liable for any acts of the firm after the date of public notice served to that effect. Liabilities. What are the liabilities of a minor before attaining majority? The liability of a minor is confined only to the extent of his share in the profits and the property of the firm. Okay, the liability before attaining majority is only towards his share in the profits and property of the firm. Minor has no personal liability for the debts of the firm incurred during his minority. He has no personal liability at all. We cannot hold a minor personally guilty. Why? Because he is a minor, as well as because he is not allowed to take part in the business of the firm because of his minority. So when someone is not allowed to take part in the business of the firm because of his minority, then we can definitely not make him personally liable. We can make his share liable for the wrong deeds of the firm. His share will definitely be a liable, but he personally should not and could not and cannot be made liable under the law for something which he has no control over. Okay, so what the firm is doing, a minor has no control because he has no power to vote. So when he has no control, he cannot be personally liable. But yes, because firm does something jointly. Okay, when firm takes a decision, that means all partners have taken that decision. So if firm is suffering some liability, the share of the minor is liable, but not him personally. His share will be liable because his share is part of the firm. A minor cannot be declared insolvent, but if the firm is declared insolvent, his share in the firm vests in the official receiver or assignee. Official receiver or assignee is someone appointed by the court to take over the assets of the firm. Okay, court appoints someone to take over the assets of the firm, or assignee is someone to whom now the assets of the firm are sold. Okay. The position after attaining majority. Within 6 months of his attaining majority, or on his obtaining knowledge that he had been admitted to the benefits of a partnership, whichever date is later, the minor partner has to decide whether he shall remain a partner or leave the firm. When he has elected not to become a partner, he may give public notice that he has elected not to become partner, and such notice shall determine his position as regards to the firm. If he fails to give such notice, he shall become a partner in the firm on the expiry of said 6 months. That is, it will happen automatically if within 6 months of attaining majority or after obtaining the knowledge that he is a minor, whatever date is later. If within 6 months from that date he does not give a public notice, then automatically we will presume that he has chosen to become a partner, chosen to remain a partner. When he becomes a partner, if the minor becomes a partner on his own willingness or by his failure to give the public notice within specified time, his rights and liabilities, as given in section 37, are as follows. He becomes personally liable to third parties for all acts of the firm done since he was admitted to the benefits of the partnership. That means previous acts will now also be, he will be personally liable for all the previous actions of the firm as well. His share in the property and the profits of the firm remain the same to which he was entitled as a minor. But there shall be no change in the share of the profits which he was earlier entitled. He will still continue to remain entitled for the same amount and same share even after attaining majority and electing to become a partner by choice or by default. By default means by the operation of law when he fails to give public notice within 6 months. When he elects not to become a partner, his rights and liabilities continue to be those of a minor up to the date of giving public notice. His shares shall not be liable for any acts of the firm done after the date of notice. He shall be entitled to sue the partners for his share in the property and profits. It may be noted that such minor shall give notice to the registrar that he has or has not become a partner. Now, this repetition. We have already discussed all this stuff, but this is just another a brief discussion, so we'll now not waste much time in it. Let us go to other portion. Legal consequences of a partner coming in and going out. This appears to be quite lengthy, and I guess we have reached our time in this session. So we will, it is advisable that we should terminate the session here only, and we'll begin this discussion in the coming session.